Good morning, everybody. Welcome to another episode of Monday Morning with Mo. I hope you're having a good Monday morning. It's a little chilly out there. But I hope you had a good weekend. I know we did. We had a great time at the Fun Spot party, so thank you for everyone who came out to Fun Spot yesterday. I think everyone had a good time. Seemed like it was a good turnout. So hopefully we can do it again next year. I hope you guys enjoyed it. And yeah, so let's jump right into this. As you know, any legal questions, give us a call. You can leave a voicemail, 407-536-6737, or you can always shoot us an email, ask@dewitlaw.com, and we'll go ahead and answer those right here. So that's what we're here for every Monday morning at 8 a.m. to answer your legal questions. So let's jump into it. So first up this morning, we got Bill. So, morning, Bill. So Bill says divorce proceedings started. We filled out paperwork through a paralegal service because neither of us can afford an attorney. And we're now awaiting a court date. We agreed to 50-50 custody. I keep the house. However, I've now learned that my wife is planning on living in a one-bedroom apartment with her new boyfriend. The boyfriend smokes in the apartment and my children are very uncomfortable being there. Is there anything I can do? So, you're waiting for the final hearing at this point, but you've already reached the agreement. So if you have concerns at this point in time, at the final hearing or prior to it, you really need to raise those final concerns with the judge. And the judge may do something, they may not do something. Between now and the final hearing, you want to file a motion to modify the agreement if you believe it's not in the best interest of the children. And so that may require some more evidence, some more allegations, some more substantiation, in other words. But you want to make sure you have that motion in the court file. It's going to be a motion to modify the agreement. Basically arguing that the agreement's not in the best interest of the children because of X, Y, and Z. And so if there's a parent who's smoking or not a parent, but a person who's smoking in the apartment where the children may be residing, maybe it's not in their best interest to be there. So those are the kinds of things that you want to lay out in the motion, and ultimately it's going to be up for the judge to decide. Now, you guys already reached an agreement. I don't know what the terms of the agreement are specifically. You say it's 50-50 custody. But the agreement always has to be in the best interest of the children. So even though you guys agreed to it, the judge can always change that agreement if it's not in the best interest of the children. So that's what you want to argue to the judge. Prior to the final hearing, you want to make sure you file that motion because that's really the only option you have at this point in time. So if we can do anything to help, if you have any further follow-up, feel free to email me directly or email back to the ask@dewitlaw.com, and I'm happy to help you any way I can. So best of luck to you there, Bill. So, as always, any legal questions, shoot us a voicemail or leave us a voicemail. Number right on the screen there, 407-536-6737. You can leave that any time of the day or night. And we'll go ahead and answer it next Monday morning, bright and early 8 a.m. So, or you can always email ask@dewitlaw.com. And it was great seeing a lot of you guys out there at the Fun Spot event. It was a lot of fun. Didn't get to ride a lot of the rides, but went down the fun slide. I think it was fast. Kind of scared the crap out of me, to be honest with you. All right, back to it. Next up, we got Saul. So Saul says, my husband committed suicide in August. Wow, I'm sorry to hear that, Saul. When he died, I took possession of all the guns he had. I turned one into the ATF per the special regulation regarding that one. The others I still have. His father asked for the guns, and I told him I had turned them in. He is now saying that he will sue me and call the police because I didn't give him the guns. He said they belonged to him, but couldn't tell me which guns he was asking for. He mentioned a shotgun, but I don't have any shotguns. He also mentioned a lower receiver, which I don't think I have. He said that he would sue me as it wasn't right for me to turn in any weapons. He said he had a probate or something. What should I do? All right. So, typically when someone passes away, any assets they have may need to be probated. So what probate essentially is it's a court case that's opened up to distribute assets. Now, given that this was your husband that passed away, typically most of the assets are going to go to you automatically. I think what your husband's father is essentially arguing is that these guns were really his. They didn't actually belong to your husband. So he could sue you for that, and then it would be up to him to show that he actually owned these weapons. And I don't know exactly how he would show that. if this is just his way of trying to get the weapons back, or if they actually were his, or what the situation is. But the probate, most likely, since you're the spouse, all the assets would come to you through the probate anyways. Unless there was, children or something like that, some of the assets may go to the children, but usually they're not going to go back to a father when there's a living spouse. So it wouldn't make a whole lot of sense that the guns would go to him in the probate. What makes more sense is that, he's saying that they're his, and therefore they should be given back to him. But he would have to show some sort of proof of that. I don't really know how he would prove that. And they may have also been gifts. They may have been gifts to his son, and he's now trying to get those back. So if he sues you, it's up to him to provide proof to show that the guns were his. Otherwise, I don't really think there's a whole lot that he can really do. It sounds like he really just wants the guns back. It's kind of my take on it, but again, I don't know all the facts. So you just kind of have to navigate it. If you don't have the guns anymore, you don't have the guns. There's not a whole lot you could do. He could sue you for monetary damages, but it'd be up to him to prove that the guns were actually his, and that your husband was really holding them in what we would call kind of a constructive trust, or holding them on his behalf. So, best of luck, and if there's anything I can do, if you have any follow-up questions, shoot us an email, askask@dewitlaw.com, or you can leave us a voicemail too, more detailed voicemail. Always great to get the details, 407-536-6737. All right, and no voicemails this week, just a bunch of emails, so feel free to leave those voicemails. Makes it a little fun, All right, email number 3 of the morning from Dawn. Hello, Dawn. How are you? All right, hello. I would like to know about Florida law regarding prenuptial agreements. Do both the future husband and wife need to have their own separate attorneys to make it legitimate and hold up in court in case something goes wrong, or can we use one attorney for everything? Great question. So we get this question a lot with prenuptial agreements as well as uncontested divorces, kind of when parties agree on everything. Can they both just have the same attorney? And short answer is no. If I'm your attorney, I can only represent you. I can't represent you and your spouse, because that would be a conflict of interest, because your interests are not aligned in a prenuptial agreement or in a divorce proceeding. So, excuse me. So I can represent you, and then it's up to your spouse whether they want to get an attorney or not. So specifically with a prenuptial agreement, what we always do is they're not required to have an attorney, but they are required to have the ability to get an attorney if they want to. So typically in the agreement, we're going to, number one, make sure it's given to them in enough days in advance of the wedding to make sure that they can have it reviewed with an attorney if they choose to do so. That's number one. Number two, if there's a big financial inequity there, you're going to want to put in the agreement that an allowance was given to that person so that they could go hire an attorney to review them if they wanted to do so. And the reason you do that is because if anyone comes back and tries to challenge the prenuptial agreement, you don't want them to say that they couldn't afford to get an attorney, therefore you weren't really giving them the opportunity to have an attorney review it. So they don't actually have to have an attorney review it, but you put in the agreement that a certain dollar amount has been allotted to them to allow them to get an attorney to review it. As long as you do those things and make sure that they have the opportunity to hire an attorney to review the prenuptial agreement, typically it's going to be upheld. It's going to be difficult for it to be overturned for something like duress. And typically there's two main attacks on prenuptial agreement. One is that the person was under duress, and that's usually it was handed to me, the second before we walked down the aisle. All my friends and family were there. I didn't know what to do. I signed the thing. That's duress. The other one is for failure to disclose your financial information. So when you're entering into a prenuptial agreement, it's presumed that everyone's entering into it with full knowledge, meaning you're fully aware what the other side's assets are. Excuse me. And you're entering into it, with full information regarding the financial picture of each party. And so typically what we do when we do a prenuptial agreement is we do a financial affidavit for each party. We attach it to the agreement. We have both parties initial it, showing that they've seen it. And that way it helps eliminate that fraud argument, saying that you didn't fully tell me what the financial situation was, therefore we weren't on equal playing fields. There wasn't an equal bargaining power when entering into this agreement. So, that's how you want to set it up, basically. So, back to Dawn's original question here. You can use one attorney, but I would only represent you. So whoever the attorney is that you hire drafted the agreement only represents the person who calls them to do that. The other spouse has to have the opportunity to go get that agreement reviewed by an attorney for it to be kind of legally binding, in my opinion. Doesn't mean they have to go hire an attorney, but that's the proper way to do it. Make sure they have the opportunity to go hire the attorney, so that if there's ever a challenge to it, hopefully the agreement will be upheld. So, great question there. And the same thing goes for uncontested divorces. We get people who call a lot of times who say, hey, my spouse and I want to get a divorce. Can you represent both of us? So kind of the same analysis applies. Can't represent both of you. I can represent you. We'll draft up the agreement for you. You review it, sign off on it. You give it to your spouse. Your spouse can have the opportunity to hire an attorney if they want to do so at that point in time. If they don't, as long as they're afforded the opportunity to do so, they can review it on their own, sign off on it, give it back to us, and then we can file the paperwork with the court. So, one attorney can never represent two adverse parties because it's pretty clearly a conflict of interest. So, great question there, Don. Thank you for shooting that over to us. Again, if you guys have any legal questions, give us a call, 407-536-6737. You can always leave a voicemail there, or you can shoot us an email, askask@dewittlaw.com, and I'll not only email you back, but we'll talk about it on the show here. So, always appreciated. Get a little coffee there. All right. Last but certainly not least, we got Doug here. Doug says, I was recently in a car accident and the body shop is in the process of fixing my vehicle. I currently have a rental car which is being paid for by the person who hit me's insurance. They called me yesterday and said I have to turn the vehicle in within 24 hours even though my vehicle isn't fixed yet. Is there anything I can do? All right. So you got a couple options here. One, you can go get your own rental vehicle, keep the receipts, and basically turn those receipts into the at-fault party's insurance company and ask for reimbursement. However, the other thing I would do before you do that is I would call the adjuster back who's telling you that you have to turn the rental vehicle. Explain to them that your vehicle's not ready from the repair shop yet. Get the repair shop on the phone if you need to. Have the adjuster ask them why the vehicle isn't ready. I mean, you really have nothing to do with it. But make sure they're communicating. Let them know your vehicle's not ready yet, and you need an extension on the rental coverage. If they won't do it, I would ask to escalate the situation, see if there's a manager or a supervisor who might be able to help you with that. Typically, in my experience, because when we handle a car accident case for a client, typically we assist them with rental car coverage and all that kind of stuff, if we can, if there's coverage available for that. So typically, in my experience, when you push back on them and you ask for that extension, usually they're going to give it to you. Usually they may ask the repair shop, hey, why is this vehicle taking longer? Maybe there's parts that they're waiting on. Maybe there's another issue that they found that they didn't realize initially that they need to resubmit that to the insurance company. But if you bring that to their attention, usually they'll go ahead and extend that rental car coverage for you so that you don't have to come out of pocket. Because I know money can be tight. You may not have the money or want to have to advance that cost up front if you can avoid doing so. So I would give that adjuster a call back first. Again, if you have to get the rental or the repair shop on the line, do that. Most repair shops are pretty willing to help you out there. Have them explain the situation, and hopefully that'll alleviate the problem to where you don't have to come out of pocket. They extend your rental, and then you should be good to go, get your car fixed, and you're on the road. So, as always, thank you guys for watching this. Any legal questions, shoot us an email, askask@dewittlaw.com. Or, leave us a voicemail, 407-536-6737. Again, a big thank you to everybody who came out to the Fun Spot event this year. It was our first year doing it. Hopefully we can do it, for many years to come. It seemed like everyone had a lot of fun. I certainly enjoyed seeing everybody out there. So thank you again for coming out and supporting us there. Otherwise, have a great week. Stay warm out there, and I'll see you next Monday morning at 8 a.m. Take care, everybody.